Before this video starts, I'd just like to make an announcement. I have the Liberal Tears mug for $14.99 on my website. It is the first link in the description if you want to go pick one up. Don't worry if it breaks when it comes to your house. I'll send you another one for free out of my pocket. I don't care. I want you to get your Liberal Tear mug. It comes in Liberal Tears white with the face, black with the face, white without the face, and black without the face. So pick whichever one you want, and it'll come to your door in about 3 to 5 days. So that should be epic. First link in the description. Thank you. Let's go on with the video.
Chairman, Director, I've got a lot of concerns, but one of them refers to Reddit. At the time that the Department of Justice, at your behest or your involvement, gave Paul Gambetta immunity, did you do so knowing about all of the posts he had on Reddit and capturing all of those posts and correspondence where he was asking how to wipe or completely erase on behalf of a VVIP, so to speak?
I'm not sure sitting here. My recollection is, and I'll check this and fix it if I'm wrong, that we had some awareness of the Reddit posts. I don't know whether our folks had read them all or not. We had a pretty good understanding of what we thought he had done, but that's my best recollection.
Okay, in the last week, en masse, he's been deleting them from Reddit posts. Is that consistent with preserving evidence? And I say that because there's still an ongoing interest by Congress, and only in spite of Reddit's own senior, what they call flak team, trying to hide it, only because a few people caught it, do we even know about it, and is this and other committees interested in getting the backups that may exist on these deletions? I guess my question to you is he destroying evidence relevant to congressional inquiries? And I'll answer it for you, yes, he is. And what are you going to do about it?
That's not something I can comment on.
Well, let me go into something that concerns this body in a very specific way. As a former chairman issuing subpoenas, I issued a subpoena, and additionally I issued preserved letters. In addition to that, now Chairman Chaffetz issued what were effectively preserved letters. Some of them were directly to Hillary Rodham Clinton while she was still secretary. Others, the subpoena in 2013 was to Secretary Kerry. These individuals destroyed documents pursuant or took it out of federal custody pursuant to our subpoena and our discovery. As a result, they committed crimes. My question to you is, when I was a chairman and I wanted to grant immunity to somebody, I had to go notice the Department of Justice, and you were consulted. Isn't that correct?
In a particular matter?
In any matter.
I don't know whether the FBI is consulted in that circumstance.
Okay, for the record, yes, the Department of Justice does not grant immunity without checking with federal law enforcement to see whether it'll impact any ongoing investigation. That's the reason we have a requirement to give notice. When the reverse was occurring, you were handing out like candy, according to some, immunity. Did you, or to your knowledge, Department of Justice, confer with Chairman Goodlatte, Chairman Chaffetz, Chairman Smith, or any of the other chairmen who had ongoing subpoenas and investigations?
Not to my knowledge.
So isn't there a double standard that when you granted immunity to these 5 individuals, you took them out of the reach of prosecution for crimes committed related to destruction of documents or withholding or other crimes pursuant to congressional subpoenas?
I don't think anybody was given transactional immunity.
Oh, really? Now, we have not allowed to make your immunities public, but I'm going to take the privilege of making one part of it public. I read them. You gave immunity from destruction to both of those attorneys, not just turning them over, the documents over, specifically destruction. You did the same thing with these other 2 individuals, Brian and Paul Gambetta. You gave them immunity from destruction.
Yeah, I don't think, well, again, I could always be wrong, but I don't have them in front of me either.
Well, because you don't let us take them out of the skiff, it's a little hard for us too. But the fact is, when you read them...
My answer, I'm pretty sure that what was granted was use immunity. In the case of those two people, coextensive with 18 U.S.C. 6001, which means no statement you make can be used against you directly or indirectly. Transactional immunity is sometimes given also by prosecutors, says you will not be prosecuted in any event for this set of facts. I don't think there was any transactional immunity.
Well, when I read for both of the attorneys that immunity was granted, it's in both cases said destruction, in addition to the turning over. Why was that? Why would you believe that was necessary, or do you believe that would be necessary? You wanted the document, you wanted the physical evidence. Why did you have to give them immunity from destruction of materials? And because my time is expiring, when you look into it and hopefully get back to this committee, I'd like to know, does that immunity apply only to destruction on the computers delivered, so that other destructions by Cheryl Mills could still be prosecuted?
Yeah, again, my recollection is no transactional immunity was given. A protection of statements was given to the Combetta guy and Mr. Pagliano.
Thank you, Mr. Chairman.
Chair, thanks. Gentleman recognized. Gentleman from Tennessee, Mr. Cohen.
Mr. Chairman, I would ask unanimous consent quickly that a group of documents be included, and I'll summarize them. They're basically the letters and subpoenas that led up to the destruction of documents that were previously held for preservation. Additionally, the blog post from Reddit, if those could all be placed to the record.
Without objection, they will be made a part of the record.
Thank you, Mr. Chairman.
Tennessee is recognized.
Thank you, sir. Director Comey.
I yield back.
The chair recognizes the gentleman from Ohio, Mr. Jordan, for 5 minutes.
Thank you, Mr. Chairman. Director, in your opening comments, you said this was an unusual case. I would say that's the understatement of the year. Husband of the subject meets with the Attorney General 3 days before Secretary Clinton is interviewed by the FBI. 9 people get to sit in with Secretary Clinton during that interview. One of those was her Chief of Staff, Cheryl Mills, who was the subject of the investigation. 5 people get some kind of immunity. 5 people get some kind of immunity, yet no one is prosecuted. 3 of those people who get immunity take the 5th in front of Congress, and one of them doesn't even bother to show up when he's subpoenaed. Supposed to have been at that very chair you're sitting at. And of course, the Attorney General announces that she's going to follow your recommendations, even though she doesn't know what those recommendations are, the only time she's ever done that. So of course this was unusual. We've never seen anything like this, which sort of brings me to the post. I'd like to put up the post that some have talked about, which is the post by Mr. Combetta on Reddit. And you said earlier that you don't know if you examined this during your investigation, so let's examine it now. I need to strip out a VIP's address from a bunch of archived email. Basically, they don't want the VIP's email address exposed to anyone. Now, Director, when I hear the term strip out email address, I think of somebody's trying to hide something, somebody's trying to cover up something, and it sort of raises an important question from these 2 sentences. Who's the they who wants something hid, and who's the VIP who also wants something hid? Director Comey, is it likely the VIP well, actually not just a VIP, it's a very, very important person according to Mr. Combetta. Is it likely that that person is Secretary Clinton?
Yes, sure.
Okay, and is it also likely that the they refers to her Secretary Clinton's staff and specifically Cheryl Mills?
I don't know that. Either her lawyers or some staff that had tasked him with the production.
So one other thing that's important on that, if we could put that back up, one other thing that's important is the date. The date at the top says July 24th, 2014. So whenever I see a date, I'm sure you do the same thing, I always look at what's happening about that same time frame, what may have happened directly before that, and maybe directly after that. So I went back to your reports that you guys had given to us. The first report back last month, August 18th, 2016, page 15. On page 15, it says, during the summer of 2014, State Department indicated to Cheryl Mills a request for Clinton's work-related emails would be forthcoming. State Department gives Cheryl Mills a heads up that she's got to go round up all of Secretary Clinton's email. On that same page, it says the House Select Committee on Benghazi had reached an agreement with the State Department regarding production of documents on July 23rd, 2014, just the day before, which I find kind of interesting. Then from your report that we got just last week, after reviewing several documents dated in and around July 23rd, 2014, Paul Combetta had a conversation with Cheryl Mills, and after reviewing a July 24th, there's that date again, 2014 email from Brian Pagliano, Paul Combetta explained Cheryl Mills was concerned Clinton's then current email address would be disclose publicly. So, sure looks to me like it's Secretary Clinton, as you said, but also that it's Cheryl Mills and Brian Pagliano who are urging Mr. Combetta to cover this stuff up. You agree?
From what you read, it sure sounds like they're trying to figure out a way to strip out the actual email address from what they produce.
Well, they're actually trying to strip it all out. PST file, everything. Here's the takeaway in my mind. Mills gets a heads up, Cheryl Mills gets a heads up in midsummer of 2014. July 23rd, the day before Mr. Combetta's Reddit post, the Benghazi Committee and the State Department reach an agreement on production of documents. Cheryl Mills has a conversation with Paul Combetta. He goes on Reddit then and tries to figure out how he can get rid of all this email. Even though he's not successful then, he has to do it later down the road with BleachBit. And then the clincher. Just last week, he's going online and trying to delete these Reddit posts. He's trying to cover up his tracks. He's trying to cover up the cover-up. So I guess the question is, and someone's asked it earlier, in light of all this, are you thinking about reopening the investigation?
I may have misunderstood what you said during the question. I don't understand that to be talking about deleting the emails. I understand to be talking about removing from the from line the actual email address. But anyhow, maybe I misunderstood you. But
the same guy later took BleachBit and did delete emails.
Sure. Yeah.
So my question is, the guy you gave immunity to, the guy who took the fifth in front of us, is online trying to figure out how to remove email addresses, change evidence, later uses BleachBit. That guy, who won't testify in front of Congress, and he has correspondence with Cheryl Mills, a subject of the investigation, Cheryl Mills, who also got some kind of immunity agreement, Cheryl Mills, who walked out for part of the questions during the interview with the FBI. Seems to me that's pretty compelling, and the timeline's pretty compelling as well.
I'm not following compelling of what. There's no doubt that Combetta was involved in deleting emails.
After conversations with Cheryl Mills.
He had the OSHIT moment, as he told us. And that's why it was very important for us to interview this guy to find out who told you to do that, why did you do that. That's why he was given use of it.
Did you know about the Reddit post when you interviewed him?
As I said earlier, I think we did. I think our investigators did. I'm not positive as I sit here.
Mr. Chairman, the guy's trying to cover up the Reddit post where he's trying to figure out how he can cover up the email addresses. And I find that compelling, particularly in light of the fact that just the day before, he's talking with Cheryl Mills, and the State Department is on notice that the Benghazi Committee wants these very documents. I find that compelling, but obviously the FBI didn't, and this is just one more in that list of things that make this case highly unusual. I yield back.
The director is permitted to respond if he chooses to do so.
No, I don't think so.
Thank you, Mr. Chairman. I want to start by acknowledging progress. I think it's important that we do so. This morning we've had 9 straight Democrats talk to the FBI about emails without asking for immunity. That's a record. And I suspect the reason that they have not asked for immunity from Director Comey is they would say they've done nothing wrong. I find that interesting because that's exactly what Heather Samuelson and Cheryl Mills' attorneys said. In fact, they said it just a few days ago, and I'll quote it. The FBI considered my clients to be witnesses and nothing more. And then Ms. Mills and Ms. Samuelson's attorney said this. I think this is the most interesting part. The Justice Department assured us my clients did nothing wrong. Well, Mr. Chairman, if you're assuring subjects or targets or witnesses, whatever you want to call them, that they've done nothing wrong, it does beg the question, what are you seeking and receiving immunity from? I mean, if you've done nothing wrong, laptops don't go to the Bureau of Prisons, Mr. Chairman. People do. So the immunity was not for the laptop. The immunity was for Cheryl Mills. And if the Department of Justice says you've done nothing wrong, it does beg the question of why you are seeking or receiving immunity. And it could be, Mr. Chairman, for a couple of different, it could be for the classified information that was the genesis of the investigation. It could be for the destruction of federal records which came from that initial investigation, or it could be both. Mr. Comey, I want to ask you this. Did the Bureau interview everyone who originated an email that ultimately went to Secretary Clinton that contained classified information?
I don't think so. Nearly everyone, but not everyone.
Well, you and I had a discussion the last time about intent. You and I see the statute differently. My opinion doesn't matter. Yours does. You're the head of the Bureau. But in my judgment, you read an element into the statute that does not appear on the face of the statute. And then we had a discussion about intent. So why would you not interview the originator of the email to, number one, determine whether or not that originator had a conversation with the secretary herself?
There were a handful of people who the team decided it wasn't a smart use of resources to track down. One was a civilian in Japan, as I recall, who had forwarded something that somehow got classified as it went up, and the other were a group of low-level State Department people deployed around the world who had written things that ended up being classified. Nearly everyone was interviewed, but there was a small group that the team decided it isn't worth the resources.
Well, to that extent, if you interview the overwhelming majority of the originators of the email, will you make those 302s available to Congress? Because I counted this morning 30-something 302s that we do not have.
Okay. I'll go back and check. My goal is maximum transparency, consistent with our obligations under the law. I'll check on that.
Well, and I appreciate it for this reason. Intent is awfully hard to prove. Very rarely do defendants announce ahead of time, I intend to commit this crime on this date. Go ahead and check the code section. I'm going to do it. That rarely happens. So you have to prove it by circumstantial evidence, such as whether or not the person intended to set up an email system outside the State Department, such as whether or not the person knew or should have known that his or her job involved handling classified information, whether or not the person was truthful about the use of multiple devices, whether or not the person knew that a frequent emailer to her had been hacked, and whether she took any remedial steps after being put on notice that your email or someone who's been emailing with you prolifically had been hacked. And whether or not, and I think you would agree with this, Director, false exculpatory statements are gold in a courtroom. I would rather have a false exculpatory statement than a confession. I would rather have someone lie about something and it be provable that that is a lie, such as that I neither sent nor received classified information, such as that I turned over all of my work-related emails. All of that, to me, goes to the issue of intent. So I got two more questions, then I'm going to be out of time. For those who may have to prosecute these cases in the future, what would she have had to do to warrant your recommendation of a prosecution? If all of that was not enough, because all of that's what she did, if all of that's not enough, I mean, surely you cannot be arguing that you have to have an intent to harm the United States to be subject to this prosecution. I mean, that's treason. That's not a violation of this statute.
No, I think we'd have to be able to prove beyond a reasonable doubt a general awareness of the unlawfulness of your conduct. You knew you were doing something you shouldn't do. And then, obviously, that's on the face of the statute itself. Then you need to consider, so who else has been prosecuted and in what circumstances, because it's all about prosecutorial judgment. But those two things would be the key questions. Can you prove that the person knew they were doing something they shouldn't do, a general criminal intent, general mens rea,
but the
and
way to
treated
prove,
other people similarly?
The way to prove that is whether or not someone took steps to conceal or destroy what they've done. That is the best evidence you have, that they knew it was wrong, that they lied about it.
It's very good evidence. Always want to look at what the subject said about their conduct.
Well, there's a lot. There's a lot. If you saw her initial press conference, it all falls under the heading of false exculpatory statement. I'm out of time, Mr. Chairman, but the director did. You started off by giving us examples of things the Bureau has done. And every one of us who's worked with the FBI That is the FBI that I know. The one that went and saved that girl in North Carolina, that is the FBI that I know. What concerns me, Director, is when you have 5 immunity agreements and no prosecution, when you are allowing witnesses who happen to be lawyers, who happen to be targets, to sit in on an interview. That is not the FBI that I used to work with. So I've been really careful to not criticize you. In fact, I said it again this morning. They wanted to know, was he gotten to? Did somebody corrupt him? No, I just disagree with you. But it's really important to me that the FBI be respected. And you got to help us understand. Because it looks to me like some things were done differently that I don't recall being done back when I used to work with them. And with that, I would yield back to the chairman.
Can I respond to that?
Yes, you may.
I hope someday when the political craziness is over, you will look back again on this, because this is the FBI you know and love. This was done by pros in the right way. That's the part I have no patience for. Sorry, sir.
The chair recognizes the gentleman from Rhode Island, Mr. Cicilline, for 5 minutes.
Thank you, Mr. Chairman, and thank you, Director.
Minutes of questioning for doing so, so thank you very much. Director, thank you for your accessibility. You have been very readily available, and we do appreciate that. This investigation started because the Inspector General found classified information in a non-secure setting, and the FBI went to a law firm and found this information. They seized at least one computer and at least one thumb drive. Did you need an immunity agreement to get those?
It was not. I don't think there was immunity. In fact, I'm certain there was no immunity agreement used in connection with that.
So did it really take the FBI a full year to figure out that Cheryl Mills and Heather Samuelson also had computers with classified information on?
No. It took us to that point in the investigation to insist that we try to get them.
Were you getting them because they had classified information or because there was some other information you wanted?
No, we thought those were the tools, as we understood it, that have been used to sort the emails. And the investigative team very much wanted to understand, if they could, whether there was an electronic hail of how that had been done. Because the big issue was, what did they delete, what did they keep?
But why did you need an immunity agreement? Why didn't they just cooperate and hand them over? The law firm did, didn't they?
Well, yes. That's a question really I can't answer. That's between a lawyer and her client and the Justice Department lawyers. For whatever reason, her lawyer thought it was in her interest to get an active production immunity agreement with the Department of Justice.
The FBI interviewed David Kendall's partner, but did not interview David Kendall. Why didn't you interview David Kendall?
I don't remember. I don't remember that decision.
Going back to this Reddit post, this is put up on July 24th of 2014. You believe this to be associated with Mr. Gambetta, correct?
Yes, I think that's right.
This is the one that Mr. Jordan put up about the need to strip out a VIP's very VIP email address and a bunch of archived email. This is he's referring to a federal record, isn't he?
I don't know exactly which records he's referring to.
How is this not a conscious effort to alter federal records? I mean, the proximity to the date is just stunning.
I'm sorry, what's the question?
How is this not a conscious effort to alter a federal record?
Well, depending on what the record was and exactly what he was trying to do, and whether there would be disclosure to the people they were producing it to, saying we changed this for privacy purposes. I just don't know sitting here.
These are documents that were under subpoena. These federal records were under subpoena. They were under a preservation order. Did Mr. Gambetta destroy documents?
I don't know whether that was true in July of 2014. They were under subpoena.
Did he ultimately destroy federal records, Mr. Gambetta?
Oh, I have no reason to believe he destroyed federal records.
He used bleach bit, did he not?
Yeah, the question is what was already produced before he used the bleach bit. He definitely, the reason he wanted immunity was he had done the bleach bit business after there was publicity about the demand from Congress for the records. That's a potential.
And not just publicity, there was a subpoena.
Right, that's potential.
And there was communication from Cheryl Mills that there was a preservation order, correct?
Yes.
And he did indeed use bleach bit on these records.
Sure. That's why the guy wouldn't talk to us without immunity.
And so when you got immunity, what did you learn?
We learned that no one had directed him to do that, that he had done it.
You really think that he just did this by himself?
I think his account, again, I never affirmatively believe anybody except my wife, but the question is, do I have evidence to disbelieve him? And I don't. His account is credible, that he was told to do it in 2014, screwed up and didn't do it, panicked when he realized he hadn't, and then raced back in and did it after Congress asked for the records and the New York Times wrote about them. That was his SHIT moment. And that was credible. Again, I don't believe people, but we did not have evidence to disbelieve that and establish someone told him to do that. No email, no phone call, nothing. The hope was, if he'd been told to do that, that'd be a great piece of evidence. If we give him immunity, maybe he'll tell us, so-and-so told me to, so-and-so asked me to, and then we're working up the chain.
But he did indeed destroy federal records, and he was told at some point to do this, correct? Who told him to do that initially? When he was supposed to do it in December, and he didn't do it. Who told him to do that?
One of Secretary Clinton's staff members, I can't remember sitting here, we know that. One of her lawyers might have been Cheryl Mills. Someone on the team said, we don't need those emails anymore, get rid of the archive file.
This is what's unbelievable about this, because there's classified information, there are federal records that were indeed destroyed. And that's just the fact pattern. Let's go back to this. Here's the other thing that I draw to your attention that is new. September 15th of this year, I issued a subpoena from the Oversight and Government Reform Committee. On these Reddit posts, 4 days later, they were destroyed or taken down. They were deleted. I would hope the FBI would take that into consideration. Again, we're trying under a properly issued subpoena to get to this information. Let's go to Heather Mills real quick. How does in the 2016 interview with Cheryl Mills, she says, quote, Mills did not learn, in the interview report, the interview summary from the FBI, Mills did not learn Clinton was using a private email server until after Clinton's tenure. Back, also, you have this interview with Mr. Pagliano, who said he approached, quote, Pagliano then approached Cheryl Mills in her office and relayed a State Department employee's concerns regarding federal records retention and the use of a private server. Pagliano remembers Mills replying that former secretaries of state had done similar things, to include Colin Powell. It goes then on to a page 10, and this is what I don't understand. The FBI writes, Clinton's immediate aides, to include Mills, Abedin, Sullivan, and a redacted name, told the FBI they were unaware of the existence of a private server until after Clinton's tenure at state, or when it became public knowledge. But if you look back at the email from Heather Mills, if you go back to 2010, this is to Justin Cooper, okay? Mills to Cooper, who does not, he works for Clinton's. He doesn't work for the State Department. FYI, HRC email coming back. Is server okay? Cooper writes back, you are funny. We're on the same server. She knew there was a server. When there was a problem with Hillary Rodham Clinton's emails, what did they do? She called the person who has no background in this, who's not a State Department employee, no security clearance, and then tells the FBI, well, I never knew about that. But there's direct evidence that contradicts this. How do you come to that conclusion and write that in the summary statement that she had no knowledge of this?
That's a question.
Yes.
The time of the gentleman has expired, but the director will answer the question.
I don't remember exactly sitting here. Having done many investigations myself, there's always conflicting recollections of facts, some of which are central, some of which are peripheral. I don't remember sitting here about that one.
The chair recognizes.
Hello, everyone. Hey, I'm just stopping by to remind you that liberals are insane. Social justice warriors are becoming more violent and triggered than ever before. Anyways, be sure to subscribe to KGP TV on YouTube and have a blessed day. Yeah, man.
A lot of concerns, but one of them refers to Reddit. At the time that the Department of Justice, at your behest or your involvement, gave Paul Gambetta immunity, did you do so knowing about all of the posts he had on Reddit and capturing all of those posts and correspondence where he was asking how to wipe or completely erase on behalf of a VVIP, so to speak?
I'm not sure sitting here. My recollection is, and I'll check this and fix it if I'm wrong, that
directly to Hillary Rodham Clinton while she was still secretary. Others, the subpoena in 2013 was to Secretary Kerry. These individuals destroyed documents pursuant or took it out of federal custody pursuant to our subpoena and our discovery. As a result, they committed crimes. My question to you is, when I was a chairman and I wanted to grant immunity to somebody, I had to go notice the Department of Justice, and you were consulted. Isn't that correct?
in a particular matter?
In any matter.
I don't know whether the FBI is consulted in that circumstance.
Okay. The backups that may exist on these deletions. I guess my question to you is he destroying evidence relevant to congressional inquiries? And I'll answer it for you, yes, he is. And what are you going to do about it?
That's not something I can comment on.
Well, let me go into something that concerns this body in a very specific way. As a former chairman issuing subpoenas, I issued a subpoena, and additionally I issued preserved letters. In addition to that, now Chairman Chaffetz issued what were effectively preserved letters. Some of them were...
Before this video starts, I'd just like to make an announcement. I have the Liberal Tears mug for $14.99 on my website. It is the first link in the description if you want to go pick one up. Don't worry if it breaks when it comes to your house. I'll send you another one for free out of my pocket. I don't care. I want you to get your Liberal Tear mug. It comes in Liberal Tears white with the face, black with the face, white without the face, and black without the face. So pick whichever one you want, and it'll come to your door in about 3 to 5 days. So that should be epic. First link in the description. Thank you. Let's go on with the video.
Chairman, Director,
We had some awareness of the Reddit posts. I don't know whether our folks had read them all or not. We had a pretty good understanding of what we thought he had done, but that's my best recollection.
Okay, in the last week, en masse, he's been deleting them from Reddit posts. Is that consistent with preserving evidence? And I say that because there's still an ongoing interest by Congress, and only in spite of Reddit's own senior, what they call flak team, trying to hide it, only because a few people caught it, do we even know about it, and is this and other committees interested in getting the